In this video, I'm going to be talking about the big mistakes that I've consistently seen criminal defendants make in their cases. What to consider when you're making decisions isn't always that intuitive and isn't always something that your attorney will talk about. My name is Veronica. I'm a criminal defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. Okay, so let's jump right in. The first big mistake that criminal defendants make, and this is especially applicable to domestic violence cases, but any case where you bond out, you were in jail, you paid, now you're not in jail anymore, you're waiting for your first court date. One of the biggest mistakes that people make is they do not hire a criminal defense attorney to represent them before court. If you're doing your research, as you obviously are, you may realize that not a whole lot goes on necessarily at the first court date. There's a little bit more in domestic violence cases that goes on at the first court date, but it's not as though it's a trial. So you may be thinking, well, do I need an attorney before then? I just spent so much money on bail, it's not easy for me to get money right now. How about if I just hire an attorney down the road? You may also realize that it is possible that the prosecution, if they have not already filed charges against you, it's possible that they will just on their own decide that they are going to drop the case and not file charges. So you may be thinking, well, I'm just going to wait and see if they file charges or not. And in fact, I know that some attorneys will actually advise you to do that. But that is a very big mistake, especially if you don't have criminal history. You are really rolling the dice if you just go ahead and wait and see what happens. Because before court, especially if it's a domestic violence case, what you should be doing is having an attorney contact the prosecution and maximizing your chances that they will drop the case altogether. Because once you show up at your court date, if charges have already been filed against you, it is going to be a lot more difficult, and in most cases impossible, to get the case dismissed. I get cases all the time where people call me after they've already been to court, they've been using the public defender, maybe now they've saved up money, they can hire a private attorney, and I look at the case and I think, I could have gotten this dropped before court. Because look, when you get arrested, you bond out and you have court coming up, the prosecution still has to look at the police report and anything else that's in the file. If you submit nothing, if you don't have an attorney, then all they're looking at is the police report and your criminal history or lack thereof. And I think it's obvious that whatever's in the police report, if you got arrested, is not going to be good for you, right? So when you're thinking about all of the reasons why you do not want to end up having a conviction on your record or going to jail, going to prison, all the reasons why you're an upstanding citizen, all the things that you have to lose, any hardships that you've overcome, maybe the alleged victim wants to drop the case. Well, the prosecution is not going to have that in their file unless you have an attorney contact them. A lot of people will try to skip this step to not hire an attorney to try to get the whole thing dropped before court, and then the case gets filed, and maybe it wouldn't have gotten filed if you had had an attorney contact the prosecution before. Big mistake number 2, telling your attorney that you don't want to take any offer, any deal at all, unless you truly mean it. You may think, okay, but I can't take a conviction on my record, so I don't want any deal. Or I didn't do this, so I don't want any deal. Well, what about if you got an offer of taking some classes in exchange for a dismissal? Or doing online therapy in exchange for a dismissal? Even if you knew for sure that you 100% were going to win at trial, and it's never 100%, no matter how good your attorney is, no matter what the evidence is, it's never 100%. But let's say that it was. Trial takes, at least a few full days, more like at least a full week or 2. During that time, you are sitting there in court. You can't do anything else. You can't work. You spend a lot of time there. You have to pay for parking at most courthouses every single day. So if you think about the time that you are likely to spend doing classes and the amount of money that you're likely to spend on those classes, it is likely going to save you time and money to simply take the classes in exchange for an actual guaranteed dismissal, which you'll never get with trial, than to go to trial. But I think sometimes criminal defendants feel like, I didn't do anything wrong, or the other person did something actually to me and they're not even charged. And they understandably feel really frustrated. And they feel like, well, I definitely don't want to take a conviction. So they think, okay, so I'm not taking a deal. But they may not understand what their options actually are. I think also some people are afraid that if they don't tell their criminal defense attorney, whether it's a public defender or a private attorney, that they're not going to take a deal, then that person will sort of sell them out and just try to get them to take the very first deal. Sometimes that is true in the case of the public defender, especially if it's at the very first court date. Your attorney literally hasn't read the police report, let alone letting you have a copy of the police report, and they're trying to get you to take a deal. I do think in that case you should say, I don't want to take that deal, because usually the first offer that you get is not going to be the best offer that they're ever willing to give you. What I tell my clients when they tell me that is, that's fine. That is your right. You do not have to take a deal. I'm not going to pressure you to take a deal. I will give you my advice. But part of my job is to make sure that there is an offer on the table for you. If you change your mind, I want you to have the option of taking a deal. I don't want you to be forced to go to trial. And I want to explore what's the best thing that I could get for you. If I can get you classes in exchange for a dismissal, most people are going to take that. In most cases, my advice would be probably to take that to avoid the risk of trial, to avoid the risk of a conviction and jail time or prison time. But not every attorney feels that way. Some attorneys, especially when they're very busy, when it's a public defender, if your attorney is maybe not that nice of a person or doesn't really care about you or your case, some attorneys will say, okay, who cares? It's not my problem. I'm not going to try to convince you. Basically, they're taking the easy way out there. What you can say is, I can't take a conviction for this case because I will lose my job, or I will potentially lose custody of my kids, whatever it may be, or I will get deported. I'm a dreamer and I will lose that and potentially be deported back to a country I don't even know. That is helpful to tell your attorney, because your attorney can use that with the prosecution, and sometimes that can be very persuasive to them. And if you are thinking, but I do mean it, I don't even want to do classes in exchange for a dismissal, it's against my principles, I don't want to do that, then make sure that you watch and consider number 3. Mistake number 3 is having champagne expectations with a beer budget. Trial is very, very expensive if you're going to hire a private attorney. The reason why it is so expensive is because it takes so much time. Not just the time of sitting there, only working on your case for weeks at a time. I've had cases that have taken more than a month at a time, not just because of that, but because that's just the time in court. When I'm in trial, I am not sleeping well, I'm dreaming about your case, I am working on your case on the weekends, in the evening. And of course, I'm preparing as much as possible outside of court before the trial starts. But once trial starts, there's always going to be some testimony that I need to refine my cross-examination overnight before we go into court the next day at 8:30 in the morning. There's always going to be something. The key to winning a trial is always going to be preparation. So if you are turning down all of the offers that you get, and not every criminal defendant is going to be offered classes in exchange for a dismissal. It really depends on your case. It depends how severe it is. It depends on you. It depends on the prosecutor. And in every single case, you are going to get to a point where your attorney says, okay, this is the last best offer that we're going to get. I have exhausted all of the options for you. I have gone to the DA supervisor. I have submitted a mitigation packet. I've sent you to classes. I've reviewed the police report. I filed any motions that could be filed that could potentially help your case. I've done everything. I've talked to everyone. And this is the last best offer we are going to get. And many times that will also come with, and it will expire per the prosecutor if you don't accept it by usually a certain court date or by the start of trial. When you are making that decision and you are deciding, do I want to take this or not, you should know that your other option is going to trial. So you really have to think about, can I actually afford to go to trial? Can I afford to hire an attorney to represent me in trial? A good attorney. You need somebody who is extremely prepared, and that is going to be extremely expensive. Yes, you can use the public defender if you qualify for the public defender, but that public defender has many other cases that don't necessarily stop just because they have your case. They are going to have their full caseload that keeps them in court all day long, and then it will be time for your trial to start. And so they are essentially winging it. So if you're thinking that maybe you want to go to trial, then you need to figure out how much the trial is going to cost and is it something that you can actually do. So you can ask your current attorney if you have a private attorney. You can also call around to other attorneys' offices. You don't necessarily need to stick with the same attorney, but make sure you have an idea of ballpark what that is and whether or not you're going to be able to pay for it. Because the worst thing that you can do in a situation like this is think, I'm not going to take any deal. I don't like that deal. I want to go to trial. I want my day in court. But you haven't realized whether having your day in court, whether having that trial is actually practical for you. This is something that attorneys don't necessarily talk to you about. Just like it is your responsibility to hire a law firm or hire an attorney that you trust to handle your case, it is also your responsibility to figure out your budget. There is an agreement between you and your attorney when you hire a private attorney that says what services they are going to do for you. And if you're thinking about going to trial, then it's your responsibility to figure out how much that would be. And it's important to start thinking about all of this early on, because if you all of a sudden are going to trial in next month or in the next 3 months, it's going to be a lot more difficult for you to figure out the financial aspect of this. I hope that you found this video helpful. If you do have a criminal case in California, feel free to give me a call. You can find my number down below. You can also book a consultation with me there. And if you did find it helpful, please don't forget to like, subscribe, and ring the bell.